So, as we all have discussed, almost all your provisions of CRPC, I presume that you all have the basic acumen to attend the problem related questions. So, from today onwards, we will at least try to solve one problematic question daily. First of all, let's start with the previous year's one, because coincidentally the question I was about to start is relevant one for today's occasion. Let's start. The question was asked in 2019 procedural law, question number 2B. The question was, a subdivisional magistrate without holding inquiry passes an order requiring a person to furnish security for good behavior and directs that in default he shall suffer rigorous imprisonment for 2 years. Discuss the legality of the above order. So, who can answer this? At least I presume that the sections you guys can tell me. (107) illegal. Okay. Without wasting time, let's discuss this one, but from later on you have to substantiate your answer. So, let me first discuss. The case was about an MP, member of parliament, Madhulimai. I presume that you must aware of his name. Coincidentally, today is January 8th and his death anniversary falls on today. He was such an erudite person. I want to share a few experience of an interesting story with you, that when in the year 1970, when Indira Gandhi was the Prime Minister, he was also the Finance Minister of our country, and at that time the budget was introduced 2 months later from the financial month. Suppose the financial year starts from March itself, but the budget was introduced in May. So, during those 2 months, the expenditure of the country or the state has to be borne by the consolidated fund of India. In order to validate that expenditure, government has to seek prior permission from the parliament. What happened in that year was, on March 31st, let me tell you first that in order to spend from that consolidated fund, a voter account has to be passed by the government, by the parliament. Without that voter account, the government can't even spend a single penny. It was 31st March and the session was concluded, but the voter account was not passed. So, then he is the person, Madhulimai, came into picture, that he thought that from now onwards, from tomorrow's morning, how the expenditure of the country is to be borne. So he then informed our Prime Minister Indira Gandhi ji. Then an emergency meeting was held in the parliament. It was announced in the radio and informed all the MPs wherever they were at that time had to come to the parliament, and an emergency meeting was conducted in the midnight, and the vote on accounts were passed. So he was such an erudite person. He was 4 times MP from Bihar. Though he was born and brought up in Mumbai, but he was MP from Banaras. Now what happened in this case, in the present case, the question was about that whether the subdivisional magistrate can order the detention without holding an inquiry, which is quite similar with the case of Madhulimai. So here is the budget synopsis I have made. I will share it in the group, but let us first see what facts of the case of Madhulimai versus Bedmurti. Bedmurti was the SI who arrested Madhulimai. There was a gathering which was to address by Madhulimai, and the police unfortunately detained him and arrested from that place, from that gathering, and right after that took before the magistrate, to the subdivisional magistrate. Then what happened? Police can arrest without warrant. That is, apart from section 41, we can refer to section 151. In fact, Madhulimai was arrested under section 151 itself, and which is dealing with which gives power to the police to arrest for keeping peace or to maintain law and order of the society. But after that, when he was produced before the divisional magistrate, he, without commencing the inquiry proceeding, he remanded him to the custody and demand a bail bond of rupees 50,000 or 5 lakhs. I was not sure about the number, but he demanded an amount, and which Madhulimai was refused to pay. Then after that, it was raised. This matter was brought before the Honorable Supreme Court. A 7-judge bench was assembled, was constituted to hear this matter, and the then Chief Justice was Honorable Chief Justice Hidayatullah, and who later on pronounced the judgment regarding this matter. There were 2 issues brought before the Supreme Court. One is whether the detention was legal or illegal, and whether the chapter 8 of Code of Criminal Procedure is constitutional or not. So now coming back to the question, to the case, let us see the fact of the case in a brief. Apprehending violent and destructive activities by the petitioners, the police arrested them without a warrant. As I said you before, police can arrest without warrant, in the apprehension of breach of peace, which is provided under section 151. So Madhulimai was arrested under section 151 and then took them before to the magistrate under section 107. Now no proceedings were drawn up under section 107 before the arrest, and after they were taken before the magistrate, On the report of the police, the magistrate drew up the order under section 112 and it was read over to the petitioners. Thereafter, under section 117 subsection 3, let me tell you that this was a case of 1970, but CRPC was came into force in the year 1973. So presently, this 1173 has to be construed as section 116 subsection 3. Okay, I will come back to the section 116 later on, but now thereafter under section 1173, the magistrate asks the petitioners to execute an interim bond, and as the petitioners refused to do so, they were remanded to custody, which is quite similar to our present question, which was asked in 2019 OJS examination. Now, the magistrate did not take any sworn statement or make any inquiry into the truth of the information before asking for the interim bond and merely adjourned the case for examination of the petitioners without summoning any witnesses in support of the information. Now, on this question of the validity of the detention, what Supreme Court was held? This was the issue. So, there were two issues: whether the detention is legal or the constitutionality of chapter 1 is valid or not. Now, solving to the first issue, whether the detention was legal or not, for that we need to understand section 116. 116 is about the inquiry which is to be conducted by the magistrate before ordering for the bond or before remanding him to the custody. First of all, there has to be an inquiry, and 116 subsection 3 mandates that a magistrate is empowered to order for an interim bond. That means he can order for an interim bond unless and until the trial is concluded. Hence, when the accused is brought before to the magistrate, there has to be, the magistrate is bound to commence an inquiry proceeding. It is not mandatory that he has to conclude there only, but sometimes, suppose the accused was arrested from Sambalpur and then he was brought before the SDM, sub-divisional magistrate. It is not possible that to maintain when the law and order of the state is at stake, it is not possible at the executive end to conclude the trial in a short span of time, to summon all the witnesses. It is not possible, that it is quite impractical that all the witnesses will present at the inquiry stage in the court itself. We need to summon them. It takes a substantial portion of time. So, it is not possible and quite impractical to conduct a trial or inquiry within a short span of time. That is why the magistrate is empowered to order an interim bond, even if without concluding the inquiry. And he has to write the reason that whether there exists a prima facie case or not. So, wait a second. Yes, whether he has to conclude, it is not mandatory that he has to conclude that whether there exists a prima facie case or not, but he is bound to institute a criminal proceeding, inquiry proceeding. Without commencing an inquiry proceeding, adjourning the case into a further date, without even hearing to the parties or to the police officer who arrested him, he cannot order for an interim bond, and in contravention of which you cannot forward the accused to the police custody or to the custody. So that's why the detention was held to be illegal in this case, Madhulimai versus Bedmurti. Bedmurti is none other than the SI who arrested him. And later on there was another case based upon the same facts, Madhulimai versus SDM Munger, in which it was held that the constitutional validity of chapter 8, and it was indeed upheld that the provisions enumerated under chapter 8 of CRPC was constitutional, and the magistrate is empowered to impose an interim bond upon the accused even if without concluding the inquiry, but he has to record the reasons and he has to institute a criminal inquiry proceeding. If there is no criminal inquiry proceeding, he cannot. So in this case you need to mention these two case laws. One is the ratio, let me tell you first, which was held in Madhulimai versus Bedmurti, that under the scheme of this code, magistrate can only as for an interim bond if he could not complete the inquiry, which I was said earlier, which I told you earlier, that it is okay, magistrate can only order for an interim bond if he could not complete the inquiry, but without instituting an inquiry proceeding, he cannot order. It is beyond the scope of section 116 of current CRPC. Later on it was held that the expression pending completion of the inquiry in section 1173, it has to be read as 116 of section 3, postulates commencement of the inquiry, which means commencing of the trial according to summons procedure. It is well written in the CRBR Act itself, no need to bother. The magistrate cannot postpone the case and hear nobody, and it acts for the interim bond. Similarly, that magistrate has to institute an inquiry proceeding. Without instituting an inquiry proceeding, he cannot order for an interim bond. It is okay that he could not, if he can't conclude that inquiry proceeding, but it is mandatory that he has to institute an inquiry proceeding. In the present case, if the interim bond were required from the petition, the magistrate ought to have entered upon the inquiry and satisfied himself at least prima facie about the truth in relation to the alleged facts. And in another case, you will come to know that the information received is not necessary that the information was from a legal source. It can come from any other source, and without making any such inquiry, the magistrate could not require them to be detained in custody. Without making, let me repeat this again, without making any such inquiry, the magistrate could not require them to detain in custody. Therefore, the proceeding for asking interim bond and the remand to custody were completely illegal. So the detention is completely illegal. And furthermore, in order to proceed or to inquire into the matter, the procedure established under chapter 8 has to be followed, but it is not necessary that section 91 or section 344 of this code will be applicable to the proceedings, inquiry proceedings under chapter 8. These are the ratios which was held, which are decided in the case of Madhulimai versus Bedmurti. But what happened in Madhulimai versus SDM Munger was that under section 117 subsection 3, that means 116 subsection 3, can be exercised without the magistrate recording evidence and finding a prima facie case after starting the inquiry. Let me emphasize on this phrase, after starting the inquiry. Don't confuse between these two case laws because they are interlinked and they are quite distinctive from one another. They are not similar in any ground, because I will tell you, I will explain it further time, one more time. But under section 117 subsection 1 and 117 subsection 3 is valid and is a reasonable restriction under article 19 subclause 2, 3, 4 and 5 of the constitution. That means, in short, if I need to conclude this, I would say, in order to answer this question, these two case laws are very important. So you have to write first that case law number 1, Madhulimai versus Bedmurti and Madhulimai versus SDM Munger. Okay. Apart from that, section 116, if possible, section 151 and 107. These things we have to write in order to secure a full and full mark. So, while citing Madhulimai versus Bedmurti, you need to write that the detention was illegal because there has to be an inquiry proceeding instituted by the executive magistrate himself. Then you have to cite Madhulimai versus SDM Munger, which states that if the magistrate failed to conclude the trial or inquiry, if the magistrate failed to conclude the inquiry, he is empowered to order for an interim bond under section 116 subsection 3. So that is all. These two case laws is mandatory, and section 116, 115 and 107, 151 and 107 is mandatory to mention in your answer. With this you can conclude this. This is a major case law where it was held that chapter 8 is not, you don't violate our fundamental right, and such provision is constitutional. I hope you guys understand this. So we have covered the first part, that is whether the detention or the order by the subdivisional magistrate was legal or not. The first part we have covered it. Now moving towards the second part, that in default of the bond amount, payment of the bond amount, whether the subdivisional magistrate can order for rigorous imprisonment for 2 years. This is our second part. First part is basically about the Madhulimai case. Now moving towards the second part, whether the order for imprisonment for 2 years is valid or not. For that we need to refer to our CRPC. First let us discuss about section 117. For that we need to discuss section 117. Let me take you to the screen. Page number 6, 82. See, here is section. Okay, here is your section 117. We suggest if upon such inquiry it is proved that for keeping the peace or maintaining good behavior, as the case may be, that the person in respect of whom the inquiry is made should execute a bond with or without sureties, and magistrate shall make an order accordingly. So, 117 empowers the magistrate to ask for bond amount, but there are three provisos to this rule. First proviso, no person shall be ordered to give security of a nature different from, mark my word, nature different from, and next of an amount larger than or for a period longer than that specified in order made under section 111. So, 111 mandates that the executive magistrate cannot order to execute a bond for a period longer than 1 year. So, the duration has to be 1 year, and as we can see here, the security demanded should not be of a nature different from the order specified in 111. So, there cannot be an order which goes against the spirit of section 111. So, you need to mention that 117 proviso A, that there cannot be an order which is different as prescribed under section 111. Now, moving towards the part of the duration, and let me discuss the two remaining provisos. That proviso number B tells that the amount of every bond shall be fixed with due regard to the circumstances of each case and shall not be excessive. None of our business. Then proviso number C, when the person in respect of whom the inquiry is made is a minor, the bond shall be executed only by his sureties. So, here our requirement is that no person shall be ordered to give security of a nature different from on section 111. So, the order has to be within the period of 1 year, not more than that. Now, moving towards section 122. Next, we have to discuss section 122. What happens there? See here, imprisonment in default of security. So, you need to mention this section also, that what happens if the accused did not pay the security amount, then in default of that payment, what the magistrate can do? So, he can, wait a second, okay, so he can order for the imprisonment also. First of all, if any person ordered to give a security under section 106 or section 117 does not give such security on or before the date on which the period for which the security is to be given commences, he shall, except in the case next hereinafter mentioned, be committed to prison, or if he is already in prison, be detained in prison until such period expires, or until within such period he gives the security to the court or magistrate who made the order requiring it. That means, the magistrate can order for imprisonment in default of the security payment. Now, this part is legal, but whether the order is, whether the imprisonment is of a nature for rigorous or simple or for a duration of 2 months, that is the matter, that is the issue here. We need to work on that. So, now moving towards directly to proviso number 8, last proviso, last subsection, that which tells us that imprisonment for failure to give security for good behavior shall, where the proceedings have been taken under section 108, be simple, and where the proceedings have been taken under section 109 or section 110 be rigorous or simple, as the court or magistrate in each case directs. That means, if the offence committed is under section 108, such imprisonment has to be in simple imprisonment. But if the proceeding has taken place under section 109 and 110, then the nature of the imprisonment can be of rigorous or simple. So, here it is not mentioned that it is a nature, it is a case under 108 or 109 or 1010, sorry 1110. We can mention both of the sections because the question is itself ambiguous. We can refer to this 122 subsection 8. If the offence is committed under section 108, then the imprisonment has to be simple, and if it is under 109 and 1110 or 110, then it can be both rigorous or simple. We need to mention all those sections. So, keeping a long story short, first of all, we can write, wait a second. So, to answer this question, we need to first write that question number 2b, that you first need to mention Madhulimai versus Vedmurti, where you will write that there has to be an inquiry proceeding. Then we will write Madhulimai versus SDM Munger, where we will write that it is fine if the inquiry is not concluded, the magistrate, the subdivisional magistrate can order for an interim bond amount, and in default of the such payment under section 122, the magistrate can order for imprisonment. If the proceeding was under 108, then the imprisonment has to be simple. If the proceeding is under 109 and 110, then it can be rigorous or simple. In no case, as 117 mandates, in no case the punishment should exceed as provided under 111, which that is either 1 year or 3 year is mentioned under 106. 106, it is mentioned that upon conviction the accused can be ordered to provide a bond for a period of 3 years. So, all these sections, all these provisos and all these case laws you need to mention in your answer, so that you can secure 10 out of 10. So, that is it. Thank you. And from now on, we will try to deal with a problematic question every day or on a regular basis. So, do your homework first. Let us do, there was a question about FIR and the corruption case of 2016, OJS procedural law. We'll discuss on that. Let me very specifically state this. That is law of contract. 2016, question number 1. An FIR was lodged against certain journalist of a national TV channel. So be prepared for this question. We will discuss in our upcoming class. Till then, happy reading. Okay. Okay, bye.